Part 5 of chapter 23. This is the last part. Okay? So, public accountability. We're kind of moving in a different direction right now, and now we're not talking about agency action so much as accountability of agencies to the public. So one method of accountability is a law called the Freedom of Information Act. You've probably heard of that before. The purpose of this is to give access of the public to agency records. Okay? So it requires the federal government to disclose certain records to any person or entity on written request, even if no reason is given for the request. Okay? And Georgia has a similar law called the Open Records Act, which applies to state agencies and the public's right to those records. The federal government must make their records available electronically on the internet or in other electronic formats. There are many records that are exempt, and you'd have to look at the list, but examples include records, for example, of national security. So you can't ask the federal government where the rockets carrying nuclear weapons are. That would violate national security. Confidential or personal information may also be protected. If the agency refuses to provide the information, you can go to court and seek an order from a federal court ordering the agency to provide the information unless it falls within one of the exceptions. Another law that protects people from or gives people some control over agencies is the Government in Sunshine Act, and Georgia has a similar law that applies to Georgia agencies. It's often referred to as the Open Meetings Law, and it requires every portion of every meeting of an agency to be open in public observation. There are exceptions to these as well. Usually there are certain things like employee relations, such as firing a person, that are exempt from public disclosure or appearance. So what you'll see is an agency go into what's called executive session if they are considering whether or not to approve the firing of an employee. The public has to be provided with adequate notice of when the meetings are going to be and what the agenda is. Some of the areas where meetings can be closed, meetings concerning the accusing a person of a crime, where the open meetings would frustrate implementation of future agency actions, future litigation or rulemaking. Courts are supposed to interpret the law liberally in favor of disclosure and allow access whenever possible. The Regulatory Flexibility Act says that whenever a new regulation will have a significant impact on a substantial number of small entities, the agency has to conduct a regulatory flexibility analysis. The analysis has to measure the cost of the rule on small businesses and consider less burdensome alternatives. It also contains provisions that alert small businesses about those forthcoming regulations. It includes various provisions to ease the regulatory burden on small businesses. And the agencies have to provide guidelines in plain English for these small businesses on how to comply with federal regulations. The Small Business Regulatory Enforcement Fairness Act says that Congress can review any new federal regulations for at least 60 days before they take effect, giving opponents of the rules time to present their arguments. Courts can enforce this act. The Office of National Ombudsman and the Small Business Administration was set up under this law to receive comments from small businesses about their dealings with federal agencies. Based upon these comments, regional small business fairness boards rate the agencies and publicize their findings. Okay, that completes Chapter 3 involving administrative agencies. If you're going to be operating a business, you must be aware of the importance of regulations, both at the state level and the federal level. One of the ways of keeping abreast of these regulations without hiring a lawyer or trying to become one yourself is that many trade organizations many trade organizations keep their members abreast of all these changes and regulations. So if you have the opportunity to join, even though there may be a fee, it's a good thing to join those organizations because that's a valuable service that they provide in terms of keeping you abreast of what you need to know to keep your business in compliance with federal and state law. That completes Chapter 23.